Good day everyone, I'm Drejer D. Homok. So for today, I'll discuss the Title 7, Collective Bargaining and Administration of Agreements. What is collective bargaining? Collective bargaining is the process of negotiation during meetings between representatives and their employer, often to improve pay and conditions. It also allows workers to approach employers as a unified group. The aim of collective bargaining is to reach an agreement between employers and workers. So now, let us proceed to the procedure in collective bargaining that is provided in Article 261 of the Labor Code. Article 261, Procedure in Collective Bargaining. When a party desires to negotiate an agreement, it shall serve a written notice upon the other party with a statement of its proposals. The other party shall make a reply thereto not later than 10 calendar days from receipt of such notice. It is referring as the demand to collectively bargain or the demand to bargain. So this is the first procedure where they send a written letter to the other parties for the proposals or suggestions. Should differences arise on the basis of such notice and reply, either party may request for a conference which shall begin not later than 10 calendar days from the date of request. If the dispute is not settled, the board shall intervene upon request of either or both parties or at its own initiative and immediately call the parties to conciliation meetings. The board shall have the power to issue subpoenas requiring the attendance of the parties to such meetings. It shall be the duty of the parties to participate fully and promptly in the conciliation meetings the board may call. During the conciliation proceedings in the board, the parties are prohibited from doing any act which may disrupt or impede the early settlement of the disputes. The board shall exert all efforts to settle disputes amicably and encourage the parties to submit their case to a voluntary arbitrator. So we all know that it is possible that there would be differences or hindi tanggap ng kalyado or yung yung other parties yung proposals mo. In that case, they may request a meeting or conference in order to settle that unacceptable terms in that proposals. If it is not settled in the conference, the board will intervene and call both parties to a consolidation meetings. Conciliation is the settlement of a dispute by mutual and friendly agreement with a view to avoiding litigation. Also, subpoenas is a formal written order that requires a person to appear before a court or other legal proceedings. So Article 262, duty to bargain collectively in the absence of collective bargaining agreements. In the absence of collective bargaining agreement or other voluntary arrangement providing for a more expeditious manner of a collective bargaining, it shall be the duty of employer and the representatives of the employees to bargain collectively in accordance with the provisions of this code. Article 263, meaning of duty to bargain collectively. The duty to bargain collectively means the performance of a mutual obligation to meet and convene promptly and expeditiously in good faith for the purpose of negotiating an agreement with respect to wages, hours of work, and all other terms and conditions of employment, including proposals for adjusting any grievances or questions arising under such agreement and executing a contract incorporating such agreements if requested by either party, but such duty does not compel any party to agree to a proposal or to make any concession. Article 264, duty to bargain collectively when there exists a collective bargaining agreement. When there is a collective bargaining agreement, the duty to bargain collectively shall also mean that neither party shall terminate nor modify such agreement during its lifetime. However, either party can serve a written notice to terminate or modify the agreement at least 60 days prior to its expiration date. It shall be the duty of both parties to keep the status quo and to continue in full force and effect the terms and conditions of the existing agreement during the 60-day period and or until a new agreement is reached by the parties. So next is Article 265. Terms of a collective bargaining agreement. Any collective bargaining agreement that the parties may enter into shall, insofar as the presentation aspect is concerned, be for a term of 5 years. So, terms means it refers to the period of the effectivity of the collective bargaining agreement. So, in representation aspect, it has a term of 5 years. So, it refers to the identity and majority of status of the union that negotiated the collective bargaining agreement. It is also the length of time as to which the bargaining agreement is effective. So for the representation aspect, the term of the collective bargaining agreement is 5 years. No petition questioning the majority status of the incumbent bargaining agent shall be entertained, and no certification election shall be conducted by the Department of Labor and Employment outside of the 60-day period immediately before the date of expiry of such 5-year term of the collective bargaining agreement. Now, this 60 days before the end or the expiry of the representation aspect is what we call the freedom period. All other provisions of the collective bargaining agreement shall be renegotiated not later than 3 years after its execution. The part of the terms and conditions of employment that were not covered by the part about representation will last for 3 years. Now, this is prohibition against injunction is contained in either Title VII of the Labor Code or the Labor Code itself, and it is an important provision. Article 266, Injunction Prohibited. No temporary or permanent injunction or restraining order in any case involving or growing out of labor disputes shall be issued by any court or other entity, except as otherwise provided in Articles 218 and 264 of this Labor Code. We all know that general we all know the general rule na hindi pwede mag-asa court na injunction or yung court yung mag-issue na injunction. So, why? Because a labor injunction is the best thing an employer can do when there are problems with workers or labor issues. So, in Article 264 of the Labor Code, then prohibited activities, it says that no person shall obstruct, impede, or interfere with by force, violence, coercion, threats, or intimidation any peaceful picketing by employees during any labor controversy or in the exercise of the right to self-organization or collective bargaining, or shall aid or abet such obstruction or interference. So, Article 267. Exclusive bargaining representation and workers' participation in policy and decision making. The labor organization designated or selected by the majority of the employees in an appropriate collective bargaining unit shall be the exclusive representative of the employees in such unit for the purpose of a collective bargaining. However, an individual employee or group of employees shall have the right at any time to present grievances to their employee. So, Article 268, Representation Issue in Organized Establishments. When a legitimate labor organization, such as natural union or federation that has already given a charter certificate to its local chapter, that is taking part in the certification election, or local chapter that has been given a charter certificate by the national union or federation, files a verified petition with the Department of Labor and Employment questioning the majority status of the incumbent bargaining agent. A majority of eligible voters must vote for an election to be valid. The person who gets the most votes is the unit's only bargaining agent. When no choice gets a majority of legal votes in an election with three or more options, a runoff election is held between the two labor unions with the most votes. As long as all of the competing unions get at least 50% of the total votes cast. For a union or federation with members and officers all over the country, it is not necessary to list their names. If a petition for certifying the election is not filed, the employer accepts the majority position of the current negotiating agent. So Article 269 Petitions in unorganized establishments. In any establishment where there is no certified bargaining agent, a certification election shall automatically be conducted by the mid-arbiter upon the filing of a petition by any legitimate labor organization, including a national union or federation which has already issued a charter certificate to its local chapter, participating in the certification election, or a local chapter which has been issued a charter certificate by the national union or federation. In cases where the petition was filed by a national union or federation, it shall not be required to disclose the names of the local chapter's officers and members. So, Article 270, when an employer may file petition. An employer can request an election when asked to negotiate collectively. The Bureau will order a certification election if the unit doesn't have a certified collective bargaining agreement. All certification cases will be decided within 20 working days. The Bureau must run a certification election within 20 days based on labor standards. In Article 271, employer as bystander. In all cases, whether the petition for certification election is filed by an employer or a legitimate labor organization, the employer shall not be considered a party thereto with a concomitant right to oppose a petition for certification election. The employer's participation in such proceedings shall be limited to first, being notified or informed of petition of such nature, and submitting the list of employees during the pre-election conference should the mid-arbiter act favorably on the petition. So, Article 272, Appeal from Certification Election Orders. Any party to an election may appeal the order or results of the election as determined by the mid-arbiter directly to the Secretary of Labor and Employment on the ground that the rules and regulations or parts thereof established by the Secretary of Labor and Employment for the conduct of the election have been violated. Such appeal shall be decided within 15 calendar days. So the next topic is the Title VII-A, Grievance Machinery and Voluntary Arbitration. So what is grievance? It refers to any questions by either the employer or the union regarding the interpretation or implementation of any provision of the CBA or the collective bargaining agreement. Pag hindi nakasunod doon sa provision ng collective bargaining agreement, it called grievance. Bakit? Kasi magkaiba yung gusto ni employer. For example, gusto niya yung income, tas ayaw niya yung expenses. Naturally, the union wants to make the member satisfied. That's why it is conflict and can cause grievances. So, Article 273, Grievance Machinery and Voluntary Arbitration. The parties to a collective bargaining agreement shall include therein provisions that will ensure the mutual observance of its terms and conditions. They shall establish a machinery for the adjustment and resolution of grievances arising from the interpretation or implementation of their collective bargaining agreement, and thus arising from the interpretation or enforcement of company personnel policies. So, all grievances submitted to the grievance machinery which are not settled within 7 calendar days from the date of its submission shall automatically be referred to a voluntary arbitration prescribed in the collective bargaining agreement. So, according to the article, if it is not resolved within 7 days, dapat dalhin ito sa voluntary arbitration. So, Article 274, Jurisdiction of the Voluntary Arbitrators and Panel of Voluntary Arbitrators. The voluntary arbitrator or panel of voluntary arbitrators shall have original and exclusive jurisdiction to hear and decide all unresolved grievances arising from the interpretation or implementation of the collective bargaining agreement, and thus arising from the interpretation or enforcement of company personnel policies referred to in the immediately preceding article. Accordingly, violations of a collective bargaining agreement, except those who are gross in character, shall no longer be treated as unfair labor practice and shall be resolved as grievances under the collective bargaining agreement. For purposes of this article, gross violations of collective bargaining agreement shall mean flagrant and or malicious refusal to comply with the economic provision of such agreement. So, accordingly, violation of a CBA, except those which are gross in character, shall no longer be treated as unfair labor practice and shall be resolved as grievances under the collective bargaining agreement. So, what is gross violation in CBA? It is considered anti-labor practices such as flagrant and or malicious refusal. Article 275, Jurisdiction over other labor disputes. The voluntary arbitrators or panel of the voluntary arbitrators, upon agreement of the parties, shall also hear and decide all other labor disputes, including unfair labor practices and bargaining deadlocks. So, Article 276, Procedures. The voluntary arbitrator or panel of voluntary arbitrators shall have the power to hold hearing, receive evidences, and take whatever action is necessary to resolve the issues subject of the dispute, including efforts to effect a voluntary settlement between parties. All parties can attend the arbitration, and a voluntary arbitrator or panel decides if a third party or witness can attend a hearing. If both sides agree, hearings can be postponed if there is a good reason or both sides agree. The voluntary arbitrator or panel of voluntary arbitrators must reach a judgment or award within 20 days of the matter being brought to voluntary arbitration unless the parties agree otherwise. So, pag hindi na-resolba within 7 days, we go to voluntary arbitrations. So, gaano ba katagal ang arbitration? So, 20 calendar days, the parties may want a longer period. So, if you want na mapa-extend, then the more money na yung magagastos mo. So, Article 277, Cost of voluntary arbitration and voluntary arbitrator's fee. So, each party must agree on how to split the cost of voluntary arbitration, which includes the voluntary arbitrator's fee. When choosing how much to pay a voluntary arbitrator or a panel of voluntary arbitrators, the parties or the Special Voluntary Arbitration Fund must consider the following. So, how do we determine the arbitrator's fee? So, first is the nature of the case. So, the more the case is challenging, mas mahal yung bayad. So, letter B, time consumed in hearing the case. professional standing of the voluntary arbitrators, capacity to pay of the parties, and letter E, fees provided for in the revised rules of court. That's all. Thank you.